Postal Monopoly Laws. George Mason University, November 2008. 5. Summary. The purpose of this study to provide a comprehensive account of the development and current status of federal laws that today grant the United States Postal Service exclusive rights in the carriage and delivery of mail. The postal monopoly gives the Postal Service a monopoly over the carriage of letters. It is one of the most ancient legal concepts to be found in the statute books of the United States. Current law may be traced directly to an English Act of 1660. The mailbox monopoly gives the Postal Service an exclusive right to deposit mail in private mailboxes. It applies to all types of mail, not only letters covered by the postal monopoly. The mailbox monopoly law is comparatively recent in origin. It dates from the 1930s. English origins. The British postal monopoly and the British Post Office were born together in the unsettled times of the mid-17th century. The postal monopoly was not established to support the post office so much as the other way around. The government messenger system was open to the public, creating a public post office in order to sustain a monopoly on transmission of private correspondence. In the early days, the fear was not that independent post offices would ruin one another, as Blackstone would later suggest, but undermine the government. Over time, however, the government monopoly became profitable, and the post office, a division of the Treasury, became a significant source of general revenue. In effect, postage was a tax on communications, not unlike its fellow revenue source, the stamp tax on legal papers. British law prohibited both private carriage of letters and packets of letters for hire and establishment of private systems of posts for the transmission of letters and packets of letters. There were 5 traditional exceptions of the British postal monopoly for the carriage of cargo: letters, letters of the carrier, letters carried by private hands for free, and letters carried by special messenger. Early American postal laws. Although early American postal laws were derived from English precedents, they soon assumed a more democratic and peculiarly American flavor. Postal monopoly laws. George Mason University, November 2008. 6. The Post Office was founded by resolution of the Continental Congress on July 26, 1775. The Articles of Confederation, adopted in 1777, gave the federal government a monopoly over the carriage of letters between the states. The first Postal Act, an ordinance adopted by the Continental Congress in 1782, included a jumbled version of the English postal monopoly laws. After independence from Great Britain was won, a new constitution was adopted that authorized Congress to establish post offices and post roads, but did not create a postal monopoly. The Postal Act of 1794 continued the proscription against establishment of private postal systems for transmission of letters. A postal system was originally a series of relay stations, established for the rapid conveyance of letters by foot messengers or mounted riders. By the 1790s, postal systems included other forms of regular stage transportation, like stagecoaches, packet boats, and even sleighs. After 1794, the early postal laws did not prohibit private carriage of letters by travelers even for compensation. Masters of inbound international vessels, and later, domestic steamboats, were required to deliver letters to the post office at the port of entry. Although this duty did not apply to passengers, there was no outbound international postal service, and outbound international letters were not subject to a postal monopoly. Although different provisions of different laws at different times variously describe the scope of the monopoly as letters, or letters and packets, or any letter or packet other than newspapers, magazines or pamphlets. A federal court in 1831 was seemingly correct in concluding that the scope of the American monopoly, like the English monopoly, extended only to letters and packets or small bundles of letters. Development of current postal monopoly statutes, 1840s to 1880s. In the 1840s, the postal world was shaken by emergence of the cheap postage movement and the simultaneous rise of private express companies. A popular outcry for sharply reduced letter rates was set off by the reduction and simplification of letter rates in England in 1840. Private express companies followed from the development of railroad and steamboat lines, which allowed passengers to easily and quickly carry letters from one city to another. Indeed, although not fully appreciated in the 1840s, the threat posed by railroads and steamboats was more fundamental than facilitation of private expresses. The steam-powered transportation revolution would eventually render obsolete the postal services, that is, the systems of relay stations, which were the original raison d'etre of the post office. Postal monopoly laws. George Mason University, November 2008. 7. Between the 1840s and the 1880s, the United States enlarged and transformed the post office. Its main job slowly shifted from management of an intercity transportation network to management of collection and delivery services capable of providing intracity as well as intercity mail delivery. If, for the average citizen, the early post office loomed large as the regular source of worldly news, the modern post office became even more important as the first practical and inexpensive medium for keeping in touch with distant family and friends and conducting business across the nation. The postal monopoly statutes were reshaped to protect the new missions of the post office. By the 1880s, a legal framework for a modern industrial post office had replaced a legal framework based on the premises and processes of a pre-industrial post office. Cheap letter postage was introduced by the Acts of 1845 and 1851. Collection and delivery services were enabled by the Act of 1851 and, most importantly, by the Free City Delivery Service introduced by the Act of 1863. By 1890, the city delivery system included 9,006 carriers operating from 454 post offices. The postal laws were revised and codified in 1872, for the first time since 1825. The first multilateral agreement on international postal laws was adopted in 1874. The modern classification system of mail was added by the Act of 1879. National and local delivery services were substantially merged by the adoption of a uniform 2-cent stamp for all intercity and local first-class letters in 1885, a rate that would last for 5 decades. During this period, the postal monopoly statutes were reshaped into what is essentially their current form. In 1845, the traditional prohibition against establishing private intercity relay, or postal, services was extended to preclude intercity, private express, services as well. In 1861, postal monopoly provisions were extended to prohibit penny posts, i.e., private intracity collection and delivery services. In each case, congressional action followed unsuccessful prosecutions under prior law. In the 1860s, the postal monopoly over inbound international mail was reinforced and its prohibitions extended to cover outbound international mail as well. The Postal Code of 1872 gathered these changes in the postal monopoly statutes into a set of 15 statutory provisions. The Postal Code of 1872 was reenacted as part of the revised statutes of 1874, a codification of the entire body of U.S. statutes. The Postal Code of 1872 also had the effect of strengthening the postal monopoly statutes in several respects. Most significantly, revised statutes Section 3982, Section 228 of the 1872 Postal Monopoly Laws. George Mason University, November 2008. 8. Code of the new code combined several strands of prior postal monopoly laws to become an all-purpose postal monopoly provision. RS 3982 applied restrictions on intercity private expresses to intracity messenger services and vice versa, and restrictions on domestic operations were applied to international commerce. Private carriage was prohibited on any postal route, a term which Congress had previously declared all to include waterways, 1823, and all railroads, 1838. In addition to pathways actually served by the post office. In 1883, the post office's monopoly over local intracity collection and delivery was secured by the judicial closure of the last private penny posts. In 1884, Congress declared all public roads and highways while kept up and maintained as such are hereby declared to be post routes. In this manner, RS 3982 became a general bar against private carriage of letters and packets on any public road, waterway, or railroad in the United States. In the Postal Code of 1872, the various phrases used to define the scope of the postal monopoly in prior laws were replaced by a single standard phrase, letters and packets. In the decade and a half following enactment of the 1872 official interpretations of the new postal monopoly law by the Attorney General and the Post Office Department reflected an understanding that the revised postal monopoly covered only letters, since the term packet in this context was deemed to refer to a packet of letters. The term letter, while not clear in all cases, was interpreted to include personal correspondence, or the idea that common usage attaches to the term letter, but not to include certain types of commercial documents subject to first-class postage, i.e., documents which were wholly or partly in writing, which but did not, in the words of international postal agreements, partake of the nature of personal correspondence. Growth of the Post Office's interpretation, the postal monopoly and its administrative role. Adoption of the mailbox monopoly statute, 1890s to 1960s. By the 1960s, the post office had grown into a universal national service that delivered letters, periodicals, advertisements, and parcels to every address in the nation, usually 5 or 6 days per week. The legal framework for the post office had been modified and enlarged but not fundamentally changed. Only in 1960 were the amendments to the postal law since 1872 collected into a new postal code. Over this period, the 15 postal monopoly provisions of the Postal Code of 1872, incorporated in the revised statutes of 1874, were consolidated into 13 provisions. 7. Postal Monopoly Laws. George Mason University, November 2008. 9. Were included in the first Criminal Code, adopted in 1909, and reenacted in the second Criminal Code. Title 18 of the United States Code, adopted in 1948. 6 of the postal monopoly statutes of revised statutes were incorporated into the codification of the postal laws in 1960. In the process, these provisions were reworded but not substantively changed. Only 3 relatively minor substantive changes were made in the postal monopoly statutes between the 1890s and 1960s. First, In 1909, Congress clarified the right of a company to carry letters relating to its current business, confirming an interpretation of prior law by the Attorney General. Second, in 1934 Congress limited to 25 the number of letters that a special messenger may carry out of the mail. Third, in 1938, Congress widened the exception from the postal monopoly for government stamped envelopes to include envelopes with postage stamps or metered indicia, affixed and canceled. During this period, the most significant changes in the postal monopoly law were administrative in nature. In broad terms, the administrative position of the post office towards the postal monopoly statutes evolved in three phases. The first phase was the development of a more expansive interpretation of the postal monopoly statutes. In 1890s, the post office interpreted the postal monopoly statutes broadly to curb the practice of railroads which routinely transported out of the mails large volumes of documents exchanged among different railroads and associated companies. Although the right of the railroads to transport a substantial portion of railroad mail was ultimately recognized by Congress and the courts, legal disputes with the railroads provided the initial basis for a broader definition of the crucial term, letter. In the 1910s, Post Office solicitor William Lamar issued a series of opinions that set out a legal rationale for interpreting the letter monopoly to include transmission of all live current communications, an approach that he argued included all of first-class mail and at least some third-class mail. Opinions by later solicitors applied Lamar's analysis to classify various types of items as in or out of the postal monopoly, usually without identifying any specific legal basis for doing so. The second phase was the assumption by solicitor Carl Crowley during the Great Depression of the 1930s of a capacity to expound upon the scope of the postal monopoly authoritatively. Previous solicitors had taken the position that the post office could not interpret the postal monopoly statutes authoritatively since they were penal in nature and therefore postal monopoly law.
Well, I hope you guys enjoyed. It's a to be continued. That means you need to Google about 3-cent stamps because they are de jour. They're backed by gold. Okay? Like I said, I'm just a guidepost. You guys need to do your own due diligence. I'm just giving you some of the resources that I have to get some of the information that I do. So I'm out. Bye.